Thank you for joining us this morning, a lovely fall morning here in DC. My name is Ken Levinson. I'm the Executive Director of WITA. We are thrilled to have so many of you here today for this extremely important topic for the trade community and the country, and I would say almost by extension, the world. This is a big deal, I think we've been told. WITA has had 10 events looking at the NAFTA. We wrapped up a series of those in September, and we're going to now that a deal is done and been signed, the text has been presented. We're hoping for expecting a signature at the end of November. We'll be doing some additional events on NAFTA. We'll be holding one on November 1st, looking at the investor-state dispute settlement provisions in that agreement. You should see some information on that in your inboxes yesterday. We'll be announcing some additional speakers for that event in the next few days, or actually even later today or tomorrow. We have a number of upcoming events in the next few weeks. We're going to be doing what's called an Fta Boot Camp, looking at Food and Drug Administration regulations and rules with a group called Registrar Corp. This is a deep dive on some topics for those of you interested in those issues. We'll be looking at the World Trade Organization, what's next for the WTO. That's coming up on November 8th. In your handouts, you see information about two other events. We'll be looking at US-EU trade with Ambassador O'Sullivan on November 15th. And then, while it says TBD, the date is not TBD. Ambassador Tim Grosser from New Zealand is retiring, and he's going to be giving valedictory remarks to WITA, and we're going to have that with a reception. That'll be on November 5th. So keep an eye in your inbox for information on how to register for all those events. So getting to this, bringing this panel back together, we've had several of the people that have been up here before as part of our NAFTA series and in other discussions that we've had over the past 2 years. I want to make a special note of our moderator, Barbara Weisel. Barbara actually kicked off our TPP series in December of 2015, so 3 years ago, and I feel like we've come full circle in some ways with a lot of twists and turns along the way. But some of that handiwork maybe we're seeing in what we're seeing now in this agreement today. So I'm very pleased to have all of you here. After our panelists make remarks, there'll be a discussion among them for a few minutes, and then we'll take questions from the audience. With that, Barbara?
Thanks, Ken, and appreciate the opportunity to moderate this important panel. This agreement, the USMCA, is the first agreement that the Trump administration concluded. So it's been interesting for all of us to watch. There are new objectives, or some new objectives, some new negotiating strategies, and provisions that we haven't seen in previous agreements. Now that the negotiations are over, stakeholders are studying the agreement, they're assessing the outcomes that were agreed, and they're evaluating the strengths and weaknesses. Congressional staff that have been speaking at various events over the last couple weeks have made it clear that they're eager to hear the views of stakeholders so members can seek changes to the agreement or draft language in the implementing legislation as appropriate to address some of the concerns that may be raised. I think this is especially important because the administration has made clear that it sees the USMCA as a template for future agreements, and you all know that they notified several agreements earlier this week. Is that this week or last week? It's all
very recent.
So as a template, it becomes very important that we're all clear what was in this agreement and what we like and what we don't like. As analysts are reviewing the agreement, there is an important question that has emerged in terms of how you evaluate the agreement, and that is, what is the baseline that you use to evaluate the agreement? One approach that a lot of people are using is to compare USMCA to the original NAFTA, and that seems to make a lot of sense since USMCA is actually going to just replace NAFTA, so that's an obvious comparison. A second approach that some feel is important is to compare the USMCA to TPP. This is an appropriate comparison also because it's important to weigh the improvements in USMCA with the breadth of the benefits we would have gotten from a regional agreement, and also to evaluate whether the opportunity costs in terms of time and political capital from negotiating one by one versus a regional agreement are justified. A third approach that some think is appropriate is to compare USMCA with no NAFTA. You know, the president has threatened to withdraw from NAFTA on numerous occasions, and so many are looking at the final conclusion of NAFTA as at least we have NAFTA, or at least we have USMCA. We reached it on the timetable that we were supposed to, and now we have an agreement, so that's the basis on which some are evaluating the agreement. So to help us understand the USMCA and assess its outcomes, we've assembled a superb panel of respected trade experts with decades of experience on trade who can use whatever comparator they want. Most of you know these folks, but let me briefly introduce them. First, to my right, your left, is Governor Matt Blunt. Matt is president of the American Automotive Policy Council, representing the common public policy interest of the U.S. auto industry. And prior to this position, he served as governor of Missouri, elected at the tender age of 33. I know you're all thinking about what you were doing when you were 33. Before that, Matt had served in the Missouri House of Representatives and as Missouri Secretary of State. Next, Victoria Espinel. Victoria is the president and CEO of the Business Software Alliance. She served as President Obama's advisor on intellectual property, and before that, as chief U.S. negotiator for intellectual property and innovation at USTR. And she was also a professor of international trade and intellectual property at George Mason School of Law. Kimberley Claman, to her left, right, is currently the director of global government affairs for Citigroup, with responsibility for international trade and investment and digital trade issues, as well as the regional areas of Asia, UK, and the EU. Before that, she too was a USTR negotiator, covering services, investment, and financial services, and was a negotiator for TPP, Chorus, CAFTA, Panama, and probably other agreements as well.
Probably others.
And finally, Joe Glauber, who is a senior research fellow at the International Food Policy Research Institute in Washington. Prior to this job, Joe spent over 30 years at the U.S. Department of Agriculture, including as chief economist from 2008 to 2014. And before that, he too was at USTR, of course, and served as the chief agricultural negotiator in the Doha talks, and worked on the Uruguay round, and was a senior economist at the CEA. So a very stellar panel, and we're interested in your comments. So let me explain how I'd like to proceed. I would like to pose questions to each of the panelists. You don't have to answer in a lengthy response because I have many, many questions, as do I think others in the audience. But I want to start out with one question for all of you, and that is to start with what do you see as the main benefits of USMCA as compared to whichever comparator you want to use. And then I will follow up with additional questions before opening it up to the audience. So let me start with you, Matt. What do you see as the main benefits of the USMCA?
Well, sure, and appreciate the opportunity to be here. I think our comparator would be no NAFTA, no agreement. And so we'd start with the fundamental thing that the best thing about it is that we have an agreement, that we have this sort of tariff-free access to these markets and the ability to have a cohesive North America and platform to produce and manufacture automobiles. So that'd be the biggest benefit of the USMCA. We do think there are some important provisions that can be utilized in future free trade agreements, particularly on the acceptance of products built to U.S. Safety standards. This agreement is the first U.S. agreement that we're aware of that includes this sort of explicit language that an economy will continue to accept products built to our standards. And then, of course, the currency provisions, which has been a long-standing objective of the AAPC, which represents Fiat Chrysler, Ford, and General Motors, has been the inclusion of currency language in a free trade agreement. So we think there are some important things that can be a part of the framework of future free trade agreements.
concise. I'm gonna continue and follow up on some of the points that you made. Matt, you mentioned the binding currency provision, and that has been a long-standing goal of your industry to get currency provision included in trade agreement. Some have raised concerns that including currency rules are risky because it subjects U.S. monetary policy to review by an international tribunal. Others argue that the commitments focus only on transparency, so don't go far enough. You said that you're happy that they're in there, but what is your view on that?
Yeah, we would have preferred a stronger provision and that more clearly defined what would be deemed manipulation for purposes of the agreement. But we do think that the U.S. government had a significant achievement, and that the transparency provisions are meaningful, and just having it in the agreement itself provides an opportunity for consultations, for example, if you think that the currency values are misaligned. So it's not as far as we would have liked to have gone, but we do think it's significant and can serve as a model for future free trade agreements.
Some companies have expressed concerns about the complexity of the auto rules of origin, especially the calculations related to the wage content requirements. What is your view on that requirement, and how onerous do you expect it to be for your companies?
Well, it's extremely complex. It's the most complicated rule of origin of any free trade agreement anywhere in the world, and it's going to be challenging for companies to comply with it. Having said that, from our company's perspective, again, for Ford, Fiat Chrysler, and General Motors, we think it's manageable, and it's something we can live with, and allows us to continue to be competitive in the global economy.
One concern raised about that particular rule of origin, the wage requirement, is that it is a process and production method requirement. And this is an issue in the past that the U.S. has strongly opposed requirements like this in other trade agreements because of the fear that it opens the door to all kinds of requirements unrelated to trade in other agreements. Is that a concern for you?
Well, again, it's extremely complex, and our companies are still trying to digest exactly how you comply with the rule of origin. So it's a concern, but as I said, we think it's a manageable rule.
Okay. Another issue on autos that's gotten a lot of attention is the quantitative restrictions that were imposed on imports of autos into the U.S. from Canada and Mexico. Will this set a precedent for managed trade in other agreements, and what are the risks of managed trade for U.S. companies?
Well, we would have very much preferred not to have the side letters on the, of course, I think you're referring to the 232, Section 232 tariff side letters. We preferred that those didn't exist. In terms of Canada, we don't actually think it'll ever be an issue. With Mexico, they may actually hit those quota limits in the next few years. So we prefer they weren't there, but the administration wanted to ensure that they were.
And the last question, the USMCA does not address the 232 tariffs. That's something that a lot of companies have commented on. So the steel and aluminum tariffs and the retaliatory tariffs remain in place. Is this a concern, and is this a priority for you in terms of what the administration does before it puts it in?
I would say it's perhaps our highest priority right now is to encourage the administration to really urgently work with Canada and Mexico to address the steel and aluminum 232 tariffs. And it clearly places us at a competitive disadvantage in terms of our global competitors. The tariffs have done exactly what you think they would do. They've increased the price of those commodities by 25% and 10%. In some places, even some points, it's been even higher than that. And that's added about $400 per vehicle to the cost to produce a car in the United States. So it's clearly undermined our competitiveness. Our biggest disappointment thus far in the negotiation has been that wasn't addressed when the agreement was announced.
So are you working with the administration to try to find a way to address that, or is that something you hope Congress will do?
Well, we're certainly encouraging them to address it as quickly as possible. Our goal would be a complete exclusion for Canada and Mexico, but they may have other ideas in mind, maybe something similar to what they worked out on the autos.
All right, let me turn to you, Victoria. What do you see as the main benefits as compared to whatever you're comparing it to?
Thanks for having me here today. So we think the USMCA is a real win for digital trade, and I'm going to compare it to NAFTA for these purposes. NAFTA negotiated 25 years ago, as everyone knows, before the commercial internet existed, before the data revolution that we're still at the beginning of had even begun. And so for the software industry and for digital trade, it's not so much a matter of updating rules that were in NAFTA, it's a matter of creating entirely new parts of the agreement that didn't exist, because of course those parts of the economy effectively didn't exist when NAFTA was first negotiated. When I talk about digital trade, a big part of that is data, which is integral to our economy, it's integral to the global economy, and a lot of the emerging tech, cloud computing, artificial intelligence doesn't exist effectively without data that can move across borders. And so for us, one of the things that is most important about the USMCA is that it has rules around data. It has a default rule that data can move across borders. It has some other provisions that we're excited about as well. But I think one thing that's really important to emphasize is when I say us, when I say, and I represent the software industry, it's not really about the software companies. It's really about the customers of the software companies, which is, at this point, virtually every company in every industry sector. So data moving across borders matters to autos because car companies are using data to improve fuel efficiency. It matters a lot to financial services. Citi uses data to try to ensure that your credit card isn't being used without your authorization around the world. It matters to farmers that are using data patterns and data information from around the world to predict harvest and make their production cycles more efficient and more bountiful. So data is, at this point, it's every part of the industry. It is woven into every part of the U.S. economy, and yet we don't have an international consensus on data. So for us, the provisions, and I can talk with more specificity about the provisions, but what's really important about the USMCA is that it is one of the steps towards getting to where we need to be, which is an actual international consensus on what data rules are.
No, you're not done.
Oh.
All right. Do you see the USMCA as a template for U.S. negotiations on IP and on digital trade going forward, or are there additions, deletions, amendments that you think are important if this is going to be the template?
Well, I wouldn't be a former trade negotiator if I didn't think the next version could always be better than the version that's just been negotiated. So I think there's a lot, as I said, in the USMCA that we think is really important. But were we to negotiate further agreements, I think there are a couple things specifically I'll mention, and I'm sure we'll probably come up with more. One on encryption. So encryption is very important for security, and the USCMA does have some language on encryption, but it could be stronger and it could be less ambiguous. So I think we have suggested, and we would continue to suggest, that there's really clear language on not allowing backdoors that would undermine encryption. And I think cybersecurity is an area which no trade agreement has really tackled. And we see around the world cybersecurity being used to discriminate against and disadvantage U.S. companies. And so I think stronger provisions that would not permit governments to use cybersecurity as a pretext for protectionism would be a great addition to future trade agreements.
And do you have any comments on privacy?
Privacy in trade agreements. So clearly we need to have an international consensus on privacy, right? And we at BSA are having lots of conversations here in the United States about what federal privacy legislation would look like, which we support. We have been engaged in the conversation in Europe around the GDPR for many, many years. We are talking to governments in Japan and South Korea and India and others about their privacy regime. So at this point, what we are doing is having a number of conversations individually with governments as they are amending their privacy regime. At some point, it would be incredibly helpful, obviously, to have a consensus, and what I mean by that is not that every government in the world has an identical privacy law, but that you have privacy laws that are sufficiently consistent and interoperable that companies aren't in a place where they have dramatically different or significantly different obligations around the world. Whether that gets worked out in a trade agreement or not, I think I'm kind of agnostic on. So if trade ended up being the right forum or mechanism to move forward on that, I think that would be fantastic. I think whether it's a trade agreement or not a trade agreement, we are going to be looking for the United States and Japan and other governments to try to move forward, and the Europeans, to try to move forward and create an actual workable, high standard, privacy protective international consensus around the world.
But not necessarily in a trade agreement. You're agnostic.
I think we need the mechanism that will work. So if that ends up being trade, that's great, and if it ends up being something else, then we'll look to that something else.
One of the issues that seems to have emerged as fairly controversial was this, the enshrining of the safe harbors parallel to Section 230 of the 1996 U.S. Communications Decency Act, and some support this approach and think it's necessary to create the environment for tech companies to flourish in the U.S., and others have said that including this provision in an international treaty at a time when the rules are evolving in the U.S. is not a good idea. What's your view?
Well, so stepping back to the specific question, I'm familiar with the dynamic of negotiating things when the rules of the United States are evolving. So I think we believe it is important to have appropriate limitations on liabilities for intermediaries in situations where they're not developing the content or moderating the content. So we are absolutely supportive of that. We're also supportive of the principle that those should be consistent with U.S. law. And our opinion is that the USMCA ended up in a, and we're comfortable with where the USMCA ended up on that point.
And let me ask, now that the USMCA has been concluded, what do you see as the best way to extend the provisions on digital economy?
So I'm really excited about that question. I'm excited about the concept. The reason that we have been so engaged in the USMCA is because we see it as, a template for the rest of the world, or that's what we would like it to be. That's what we had said about the NAFTA renegotiation for a long time. It was a great opportunity to try to move forward a consensus on international trade with two trading partners that also see innovation as part of their future. So what I would say to your question is I think the U.S. should not be afraid to negotiate digital trade and data rules in every trade negotiation that they enter into. I think they should be looking for forums outside of trade as well. I think they should be looking for every single possible place where they can move forward an international consensus on data rules that would have as its default rule that data can move across borders, that would prohibit governments from forcing disclosures of algorithms and source codes in order to get market access. I think the U.S., Japan, and India are, and the EU are great opportunities to do that. I think it would be a missed opportunity for the U.S. to not take it. I think it would be shocking to conclude an agreement with Japan or the EU that did not include a consensus on data. So we feel strongly that this is a place where the United States should take leadership. And I will say, it feels a little bit like where we were with intellectual property back in the 80s, before the WTO had been established and negotiated, when the United States took leadership, realized how important intellectual property was going to be for the United States economy, but also the global economy, and really took a leadership role in making sure that intellectual property was part of the international trading system. And I think we're at that moment now. Data is already incredibly important to our economy. It is clearly only going to be more important to our U.S. economy and the global economy in the future. And so I think the United States, but I would also call on Japan and other governments, have a moment to seize and try to make sure that we have an international consensus, because what we have now is not sustainable. The importance to the economy and the lack of international rules is not sustainable. And so, again, I think the U.S. should be looking for every opportunity it has to negotiate strong digital trade rules.
Thank you. I have more questions, but I'm going to come back because I want to move on. So Kimberley, let's ask you the same first question as what do you see as the benefits compared to whatever you want to compare it to?
well, as a former trade negotiator, of course, I'm going to compare it to all of the categories. And that is, as you can imagine, for the financial sector, having stability in terms of making sure that this agreement the outcome was a trilateral agreement, because that's what was important to our clients and customers, as well as to the financial institutions themselves. So from that perspective, trilateral was the way to go. Second, we do look at this agreement as an opportunity to modernize for the financial sector. You may be, and the biggest outcome for us, and it wasn't planned this way, but having Victoria talked about the data issues, I will say that our CEO often talks about our company as a tech company with a banking license, because that's just how much financial institutions rely on data and the ability to move that data around the world. So the biggest, I would say the most significant outcome for us in this agreement is the free flow of data provision, and also for the first time, a provision that will prohibit data localization for financial institutions. You may recall that this provision was not included in the TPP. The prior administration was still developing its policy around these issues, and so for the first time in USMCA, we will have that protection. And just for a little history lesson on that point, the free flow of data provision that is included was also updated to reflect the fact that we no longer move data in terms of just processing data. The NAFTA had included a free flow of data provision, believe it or not, for our sector, but it was limited to the ability to process that data in another country. So those have all been updated. And just because we're talking about data, I will also note that in the digital trade chapter, the protection of not having to give your source code or algorithms to governments, and the new provisions on working together on cybersecurity provisions is also important to our company. And financial services, in fact, was excluded from some of those provisions in TPP as well. So we really feel like the administration took a look at both the NAFTA and at TPP and other agreements that the U.S. had concluded, and really tried to see what would a modernized chapter for financial services look like. Just 2 or 3 other points that we see as beneficial outcomes for the sector. For the first time, there will be in a U.S. agreement on a provision on electronic payment systems that will be subject to national treatment, or as we all like to talk about, non-discriminatory treatment, and that was also not the case in TPP. In addition, the market access article, which is an article that prohibits governments from imposing a limitation, for example, on the number of suppliers of those types of services, that provision will also apply to EPS. Second, you may be aware that the United States and the financial sector had long included provisions that allowed for the cross-border service of investment advice and portfolio management advice. However, although those provisions allowed for that service to be provided, it was not subject to non-discriminatory treatment. And again, for the first time in USMCA, those non-discriminatory treatment elements of national treatment of MFN will apply. And the same is true for the market access provision. In prior agreements, both NAFTA and all the way through trade agreements, this market access article that I alluded to only applied to investment. Now it will also apply to cross-border services, all cross-border services that are defined in a positive list. They largely relate to insurance, but will now include these things that I talked about: portfolio management, investment advice, and electronic payment services. The chapter also expanded its transparency